Hey, this is William from Fed Employees Fite um, EEO abuses. Hey, look, I just read one case to you. I actually mislabeled their recording. It was claim number 12. And I just want to read one more before I call it a night. And of course, tomorrow, I got to get right back on my game. So if you allow me, as I was explaining, I'm doing at the reconsideration phase of the EEO process. And the reconsideration phase, reconsideration is not an reappeal. As a matter of fact, you don't even have a right or entitlement to it. So I've been through the initial ruling, and I'm not being sour grapes. But as I'll read to you in a minute, there was a whole lot of erroneous interpretation and improper procedure by the AJ in that ruling. So then that took me to the appeals phase, and they repeated the same deal. Hey, I kind of have some understanding. If every federal employee, we know that a lot of employees take advantage of the system or abuse the system when they're just pissed or upset about some other stuff. But so there has to be a process to weed those guys out, right? But there's also for all the people, all of us who actually have been retaliated against, have been subject to hostile work environment, harassed, discriminated against. We know in our guts that we've been cheated. Often we just don't know how. We can't articulate the cheat to the law and the requirements. Once we get an EEOC court, it gets even harder. So in this case, I'm at the reconsideration phase, and I just like to read item A. That was B I read a few minutes ago on the other recording. And I just like for you to, hey, check it out, evaluate it, see if it kind of resonates with your case. I'm a pro se complainant, meaning I'm doing it all by myself. I'll do it by myself right now as I go through the EEO process. Doesn't cost. And then I'll collect as much evidence I can to prepare for circuit court. What's the deal? All right, I want to have some hope, and hopefully EEO process will deliver some form of justice. But I'm not. I've seen too much, and I've read hundreds of cases. I'm telling you, if you want to fight this fight, you have to be educated. Even if you have a lawyer, you have to be educated. You have to work with your lawyer. You have to, hey, have your lawyers send you his responses and prepare response in advance. You read it, you go over it. And you guys work together as a team. Lawyers lose. The loss rate is 98%. That's with lawyers and without lawyers. So most of us, we're in for a rough emotional roller coaster. So item A, the AJ decision involved a clearly erroneous interpretation of material fact and or the principle cited in EEO Compliance Manual, Section 8, Retaliation, number 915.003, and Texas Department of Community Affairs versus Burdine, and de novo pursuant to 29 CFR 1614.405A, when she improperly ruled on Claim 9 in the July 29th, 2020 decision. All right, so initially, you see right there, I initially have to, that's a requirement. I have to state and provide evidence that the judge clearly made her decision clearly erroneous interpretation of material fact or law. The other part is and or does something seriously damage, ruin, I don't know, the rules and policies and procedures of the agency. I haven't seen or read a case where anybody fought on that ground yet. I guess it's too easy to back down. So, any rate, so we keep going. I'll keep reading. On June 20th, 2027, the complainant received a letter of counseling. Anybody receive a letter of counseling? Was placed in an absent without leave status for 25 minutes. There used to be a common law where the EEO understood or generally accepted letters of counseling as disciplinary. Did a lot of searching lately. Can't find it. It seems to have been obscured and wiped off and, kind of let it disappear. So that's no longer doesn't appear to be a standard. But I've also read in many cases where employees said they were issued a retaliatory letter of counseling, but you have to defend that. You have to provide evidence for your assertion that it was retaliatory. All right, listen to me how I go at this and tell me what you think. The AJ ruled as the agency's legitimate, non-discriminatory reason for issuing the complainant a letter of counseling and charging him AWOL for 25 minutes. That's claim 9. Mr. Westmark, I'm supposed to tell his name. Mr. West stated that complainant failed to attend a telephonic meeting regarding his mid-year review. Complainant does not dispute failing to attend the telephonic meeting regarding his mid-year review. Mr. Westmark stated that he issued the letter of counseling and AWOL charge after he made several attempts to schedule and conduct the complainant's mid-year performance review, to which complainant repeatedly refused to participate. Now, this is the reason why the judge is saying why she dumped me. Complainant does not dispute these facts. Really, Your Honor. And instead argues that the meeting was in retaliation for engaging in protected activity because Mr. Westmark began attempting to scheduling the meeting shortly after complainant engaged in EEO activity. Just right there, she blended a lie in with a fact. I definitely dispute those statements, and they're not facts. See how the judge already turned it around? Said because he said it, that makes it facts. No. What he says have to be, and what I say as well, have to be backed up with evidence. Can't be accepted as a fact. Did you see that quick sleight of hand? It's a quick sleight of hand. They cheat you. However, complainant has failed to prove that his protected activity was the basis for Mr. Westmark scheduling the meeting, issuing the letter of counseling, or charging him AWOL. Let's take a look at that too. Again, and that's what that's why she tanked me. So now here's what I say. Again, this statement is improperly based on the defendant's. Let me take again out. What happened is I moved this claim around. It was down somewhere like item J. I moved it up to A. I want to lead off with a relatively rock solid case. So I say again, this happened repeated. There's a repeated theme in the judge's ruling. So I'm pulling that out. Thanks for letting me read to you. I can see my errors. This statement is improperly based solely on the defendant's testimony, which is truncated, incomplete, and taken out of context. But the ROI investigation evidences, and I put the ROI page numbers on there, ROI exhibit F2A, page 000191, that the complainant was unexpectedly pulled off by an unplanned priority customer help request in performing his help desk and support duties, and evidences the supervisor's false claim in his June 20th, 2017 LOC when he falsely accused the victim, stating, "You offer no reason for your failure to attend." Pardon me. And I also cite where that is in the ROI. Be pretty specific when you exhibit. How do I spell exhibit? All right. Be pretty specific when you tell where it is. You don't want the judges to have to fumble around looking through, and they won't do it. They have clerks maybe help them out, but they're not going to really. ROI exhibit F2A, page 000192. Even when you include the evidence, as we see, they don't even look at your evidence. That's because they're not giving out justice. Here it is. So, hey, Will, you're sour grapes. Here's the evidence. The supervisor nor record has any evidence to contest or dispute the complainant's reason for missing the meeting. Instead, the record proves that he notified the supervisor via email at or about 9:38 hours of his help desk fulfillment obligation, and there is no record of the supervisor giving any response or further instructions to stop the complainant. thereby disputing the agency's proffered non-discriminatory reason and proving it to be illegitimate or pretext. But record indicates that AJ improperly and falsely ruled, stating complainant does not dispute, failing to attend the telephonic meeting regarding his mid-year review, and complainant does not dispute these facts. I need to pull one of those out because it's true. I don't dispute that I failed to meet. But what I did was explain why I failed to meet. The judge omitted my explanation, not just my explanation, but the evidence that I presented for that. See these dirty tricks they pull on you? She kind of hodgepodged the information together to make it fit a certain narrative. You read it. Here it is. The AJ further went on to only accept the agency's unsupported and bare word / testimony when she ruled, and that is a very key phrase. The judges sling that around. I borrowed that. When she ruled, stating, Westmark stated that he issued the letter of counseling and AWOL charge after he made several attempts to schedule and conduct complainant's mid-year performance review, to which complainant repeatedly refused to participate. Now see how they pointed on me? That's what the judge say. I'm telling you, it was improper for the AJ to rule, stating meeting was in retaliation for engaged in protected activity because Mr. Westmark began attempting to schedule a meeting shortly after complainant engaged in EEO activity. However, complainant has failed to prove that his protected activity was the basis for Westmark scheduling the meeting, instead issuing the letter of counsel charging him AWOL. Something else. The way in my agency they picked on me with this, by the way, letter of counseling, you can't contest it. You can't appeal it. You can't rebut it. I'm glad we said this. I'm going to put that in here. And by the way, the AWOL charge, you can't either. So once they slam those two guys on you, you're stuck with them. There's no process. There's no formal policy. There's nothing I can do to rebut, contest, appeal, or in other words, don't get any due process. Aren't they cruddy? All right. Let me continue on. The ROI exhibit, keeps misspelling exhibit. Exhibit F2A, page 000189, provides material and substantial evidence that the June 15th, 2017 sudden mid-year review meeting, go with this, meeting request. Sorry, guys. Happened within 24 hours of the complainant's June 14th, 2017 protected activity to SO2, Mr. Kleiner, in which he informed SO2 of SO1 many violations and PPPs and asked for help and a fresh start. Was a reprisal executed in close proximity to the prior protected submission, and the record fails to corroborate or evidence to support the claim of he made several attempts to schedule and conduct. Again, it was already scheduled, verified and confirmed to happen. So the judge just put that, well, the judge didn't make that up. The supervisor made that up. The judge took his word for it when she wasn't supposed to. There's no evidence to support several attempts. Makes it seem like I didn't want to participate. But that's irrelevant. What's relevant is that we already had it scheduled. We already agreed that we were going to meet at 9:30. I got pulled off. Emergency help desk. Great, lucky coincidence, right? But I had nothing to do with it. I had to do my job. And I emailed him and let him know. He didn't mention that. The commission has held that this causal connection may be shown by evidence that the adverse action followed the protected activity within such a period of time and in such a manner that a reprisal motive is inferred. I'll tell you something else I learned about that. You see the adverse action? Hopefully I remembered to explain why this LOC is adverse to my career. Because though I may win this whole chapter, they say, LOCs aren't adverse. They're just, It's just a buddy chat to help you tighten up a little bit. Nah, no. The fact is, they use those LOCs and those sentiments reflect at the end of the year rating time. So it's adverse. It's another trick. Don't let them get you on it. Let me start. Where was that? The commission has held that this causal connection may be shown by evidence that the adverse action followed a protected activity within such a period of time and in such a manner that a reprisal motive is inferred. See EEOC Compliance Manual, Section 8, Retaliation. See? So that phrase I just said comes straight out the manual. I didn't make that up. That's out of the manual. You want to stick to the manual. You want to cite the laws, the court cases. You want to repeat the verbiage that's in there that apply to your case. See also Lee versus Department of Interior. That's where I work, Department of Interior. Notoriously cruddy. Citing Simons versus Department of Justice. And also McMillan versus Postal Service. EEO appeal number blah. And Whitmer versus Department of the Air Force. So I list all those court cases that spoke to, cited that section of the EEOC Compliance Manual, Section 8, Retaliation. So in this case, I'm saying, hey, that was wrong. Her interpretation was wrong. What was that clue I just said? You guys I need to remember to go back and fix it when I'm done. All right, let me keep going. The AJ failed to recognize that the pretext and temporal proximity were sufficient evidence of retaliation, but the complainant avers, take the E off of that the LOC was part of an ongoing body of LOCs which used to lower his annual, I did get it in, DI 3100 EPAT ratings, and retard his promotional opportunities. So now I just cited how that was averse. It was an adverse action. I'm telling you, they're slippery. They'll cheat you. The record failed to provide evidence to refute or rebut the allegation. Therefore, the injury and harm of the LOC impacts the condition of his job or career, making him aggrieved. See, I'm digging in a little bit more, saying how that LOC can hurt me. I'm aggrieved because of that. Gotta be. Only thing at that point, judge can say, hey, well, I disagree. You weren't aggrieved. But you have to say it. The AJ's ruling on the claim unfairly and improperly ignored complainant's overall claim of harassment and defined his claim in a disjointed manner, leading to fragmentation of complainant's complaint. In preamble to the 1614 regulations issued July 20 of 1999, the commission advised that fragmentation of EEO complaints was a serious problem in the federal sector and that harassment/hostile work environment claims are particularly susceptible. See, I didn't make that up. That comes straight out a particular court citing ruling. See Drake versus Department of Air Force and EEO Opportunity Management Director CFR 29 CFR Part 1614. EEO MD 1T Chapter 110 Chapter 5 at 3 August 5th 2015. You gotta cite it. You can't leave it up to them to be knowledgeable, know, and map what they know to what you're saying. They're supposed to, but they don't. A claim refers to assertion of unlawful employment practice for which, if proven, there is a remedy under the federal equal employment statutes. ID. Fragmentation often results from a failure to distinguish between the claim the complainant is raising and the evidence, that's the factual information she is offering in support of that claim. When each piece of factual evidence, usually consisting of a single incident, is identified as a separate and distinct legal claim, it ignores the complainant's real underlying issue of a pattern of ongoing discrimination. I didn't make that up. I just pulled that right off one common ruling. Injustice will result if reconsideration is refused. I didn't make that up either. I pulled that out. Court cases. That is, the movement demonstrates that some harm, legal or at least tangible, such as him not being able to prove his claims of discrimination, hostile work environment, and discriminatory retaliation due to fragmentation would flow from a denial of reconsideration. See Cobell. and Bank Julius, quoting FBME Bank Ltd versus Nuchin. You see, again, I didn't make that up, and I cite the court cases where that is already a precedent. For complainants, fragmented processing can compromise their ability to present an integrated and coherent claim. Fragmentation of EEO claims must be prevented at all levels of the complaint process. Complainant's complaint and its attachments unmistakably rise a claim that he was harassed by SO1 and SO2. I got that wrong. See, I just pulled that directly out of a court case, the court case that and SO3. So I changed that to SO1, SO2, and SO3. I pulled it directly out of a court case. So kind of tell it a little bit. I had 3 supervisors harassing against me, not just 2, as in that court case where I pulled it from. And subjected to a hostile work environment and discriminatory retaliation. The March 2nd, 2022 decision failed to review the record and above facts as required in a de novo review. CFR 29 CFR 1614.405A, when it upheld a decision ruling of, with regard to Claim 9, it stated, with regard to Claim 9, the AG observed that complainant was issued a letter counseling and the absence without leave AWOL charge after several attempts were made to schedule and conduct complainant's mid-year review. Again, see how she's regurgitating that? It's irrelevant. We are established that the date was secured, to which complainant repeatedly refused to participate. And AJ also determined that complainant did not establish that the agency was motivated by discriminatory and retaliatory animus. But we just read right here that by the judge fragmenting my case, she impairs my ability to prove harassment and retaliation. She didn't look at the proximity or the temporal proximity to any prior protected activity. The prior protected activity was less than 24 hours before. Isn't that rotten? It's called temporal proximity. And therefore, he failed to establish that any of his claims amounted to a hostile work environment. See how they put the tail man in front of the dog? The complainant petitions the commission to reverse the ruling for claim number 9. View it most favorable to the non-movement and award summary judgment to the complainant for claim 9 with punitive and compensatory award. Get it now? Makes sense? All right, that's it, man. That's it for tonight. I think I'm going to try to go to bed. I dream about this stuff when I'm in these fights right here. And it's amazing. It's only my faith in keeping me alive because this beast, this monster is so insidious. It's really get depressed. You get emotional. It's really a rough ride. There's a lot of pinning hopes on, that where that you've been cheated, wronged, abused, hit with a PPP, and you're hoping that the system, you have no clue how really corrupt the system actually is, but you notice that it keeps going against your favor. And you wonder yourself, am I right? Am I wrong? What's going on? Is it my attorneys are cheating me, robbing me? By the way, these attorneys, if you notice, read every court case, there's always a statement for attorney fees. The attorney gets paid by the agency, usually $270 to $350 per hour. So if they get you to settle in a settlement that doesn't work to your favor, that injures you, doesn't make you whole again, that's why their real master is paying. Can you argue with your attorney? No. Your best thing you have to do is learn, grow, study these court cases. When you go into EEO, your full-time everything is learning the EEO process. All right. Thanks again. Bye-bye. Good night.